Hello, everyone, and welcome to another episode of Done and Dusted with my fellow cohort in crime, Counsel from Counsel Family Lawyers. And tonight's special guest is His Honour, the Honourable Justice Tom Altobelli, who's a Division 1 in the Family Law Court, who presides in Sydney, actually. So we're very grateful for him to come on board tonight. Welcome, Judge.
My pleasure.
Yes. And thank you for joining us. We've been talking over the last few weeks, Caroline and I, to a number of guests from different fields of expertise in relation to children and the importance of the children's voice in proceedings, whether it's by way of a family report and what they've got to say, or via an ICL, or tonight, of course, we have you, Judge, and you'll be able to tell, no doubt, in relation to your experience, the importance of children's voices in family court proceedings themselves.
Look, very much so. It is critically important. And I've got a sense, Darren, that we're entering into almost a new era of heightened interest and sensitivity about hearing children's voices. And we're just looking at this issue from almost with fresh eyes, which is really good to see. And understanding that hearing children's voices doesn't stop at just understanding what their preferences are in a case. And in fact, it extends to, for example, possibly involving them as much as possible in the decision, and certainly explaining the decision to them afterwards in a way that helps them gain a bit of closure, in the same way as hopefully ending cases brings a bit of closure for their parents. So this is a really, really interesting topic, and I sense there is much, much, much more to be said about it in the future.
Yeah, I'm glad you said that, Judge, because maybe it's just me because of my stage of my career and Caroline's too, because Caroline was one of the initial independent children's lawyers. They used to be called something else back in those days, but one of the initial ones here in Melbourne, and a very good one. But I'm getting the same vibe as well. I don't know what it is, but I'm certainly seeing that judges are wanting more information about children and following that through in terms of the important measures taken by judges and the impact of their decisions upon children. Mm-hmm. What do you say, Caroline?
Yeah, look, I agree. There used to be the occasional judge who would, particularly if there was an adult child in the mix, say in the SIB group, I've seen judges in certain registries invite those older children to sit in and hear reasons for judgment in the past. I think also, Judge, it's got a lot to do, and Darren, I think it's got a lot to do with the fact that we're empowering children a lot more to be active and to think independently and have a voice in every other aspect of their lives. So why is it that when we get into the family law space, we suddenly want to protect them? We want to muzzle them almost. It's done with good intentions, but it has the effect at the end of the day of muzzling children. So I think we are at that crossroads, particularly with a Labor government about to bring in legislative change, and particularly when independent children's lawyers are being given back some of that contact and therefore being able to represent children in courts, having met the clients that they're representing.
Do you think, Judge, it emanates from the older adage, children are to be seen and not heard? Because there's a certain conservatism of that which seemed to spill over to the 1975 Act.
I hope that we've come a long, long way from there, Darren. I think that there are other issues that perhaps have put Australia behind other parts of the world in terms of hearing the children's voice and integrating children into decision-making, including after the decision is made. I think one of the things that we've truly been blessed with is a family court system that provides for children to be independently represented, and in-house family consultants, child experts now called, of course, who can meet with children at all stages of the proceedings. So there's actually a lot been going on in this space, and hopefully that is an explanation for why judges have not been as active in this space, and that's because we've got highly talented independent children's lawyers. We've got highly talented child experts. So therefore, we have not had to be directly involved in it in the past. But perhaps even now, it's time to reconsider that, because most litigants want to hear it from the person who's making the decision. So why shouldn't that also apply to children? I want to put a caveat here, and I know this, look, I suspect the three of us are on the same page about this, but just for the sake of those who are listening and watching, there is no painting by numbers on this issue. There is no one way of ascertaining the views of a child and communicating that to the court. Every child is different. Every child, even children during the same developmental stage, present with very different needs and different interests. So please don't think that in the discussion we're having, it's possible to somehow simplify the issues. It isn't. This is really, really complicated, as well as being really, really important. And the idea is to come up with a system which, if possible, is individualized for every single child who comes near the court, let alone goes through the court system. That's a big ask. You know what, on balance, I think we've done a pretty good job in the past, but I think also there's much more we can do in the future. Yeah,
and also, Judge, I'm always very cognizant, not only that of the unique child to every case we do, but the unique children, each one of them within a SIBship, right? Mm-hmm. And that's what we forget about too. We often group children together in a SIBship when we know, or certainly know as a parent, each child is so different, so different.
Yep.
In terms of their needs and wants and development. Yeah. Have you found, Caroline, over the last few years that things are really turning around as far as the way we deal with children's wishes, their voice in litigation?
Definitely. It's interesting because, of course, I made a conscious decision to step away from the independent children lawyer role to work more closely with parents in terms of prevention. So trying to make sure that they never ended up in the court system. Having said that, I think it really is very powerful for us as practitioners, once a family is in the court system, to differentiate from what our client might be wanting and educate them about their children being unique and having their own views. So, Judge, I'm really, I think that's a really powerful commentary that you've made about children are unique and each child has to be considered. Darren, your point about differences between children in the same SIBship. I think we are coming up with better nuanced approaches to listening to children. And I think we were always keen to do it. We were always wanting to do it. But there was this overriding view that, you know, what's good for one child's good for the rest. There was almost like a cookie cutter system in the past. And that's where that really very archaic concept of alternate weekends and half school holidays came from. So I would be saying the profession has moved away. The courts have definitely moved away. And I think with this new legislation, we have the potential to go back to that concept of focusing entirely on best interests, which do not necessarily align with the parents' perspective about what's the best interest of children.
Yeah, that's for sure. I remember as a very young practitioner, Judge and Caroline, I remember going to court once. It probably was my first or second trial, and it was Justice Trivo. Do you remember him? And
Do
he said to
indeed.
me, we're talking about the children, and he said, look, I'm not really assisted by the affidavit material because I don't really get a feel for these children, who they are, what they like doing, what's their favourite lolly, just silly things, but things that, make up the tapestry, the rich tapestry of children. And I've always been conscious of that because a lot of materials don't really assist judges with getting a feel for the children, except for naturally family reports do to a certain degree. But I just think taking it one step further, and even as you said before, Judge, even the capacity of a judge to introduce themselves to the children and maybe at the end of the day explain to them in developmental terms what the impact of the orders are, or I don't know whether you even go that far, but it'd be nice to do it. My view is it'd be nice to do it in a harmless way to children that's not stressful, that's safe, and where children can get the benefit of knowing if mum and dad can't work it out, well, this bloke, Justice Altobelli, is going to be the one who's going to decide how things work with mum and dad as far as my time's concerned. Oh, what do you think about that?
Well, look, it sounds great, Darren. It's ambitious. Can I tell you that I've tried this once?
Have you? Oh, okay. I was going to ask you that.
And it was both an exhilarating and terrifying experience because it just came up in the list one day. And in this particular situation, I had heard this long and difficult alienation case. And I don't use that word lightly. The expert evidence described it as alienation. And the 13-year-old child who had been alienated from dad, after I delivered judgment, wanted to talk with me. And both mum and dad and the independent children's lawyer supported that. I suspect they each had their own interest in my doing that. But in any event, I did. All of this happened on short notice. I didn't go to court that morning thinking that this was going to be an event that was really quite significant in hindsight. He came in assisted by a support person. We would have spent an hour together. I explained my reasons. We agreed to disagree. This is a highly intelligent 13-year-old boy. He was really impressive, I've got to say, and I found myself respecting the parenting abilities of both mum and dad so much more as a result of having met their son and seeing just what an impressive young man he was. At the end of the day, we agreed to disagree. Now, that's all very well, but a month later, his dad filed a recovery application. And you see, the problem for me was I was no longer dealing with a child in an abstract. I was dealing with this young man, this impressive young man who I had met in person in my chambers and had formed a relationship with. And let me tell you, with the benefit of hindsight, that made it so much harder to make the recovery order. In fact, I didn't. Now, do we really want the objectivity of judges to be compromised as a result of having this sort of level of personal interaction with a child? Can I tell you that I've thought about this because this happened almost 10 years ago. I've thought about this many, many times, and I'm absolutely 100% sure that the decision not to make the recovery order was the right one objectively. But at the time, it felt like I couldn't make a decision in relation to a child who was no longer an abstract person on paper, but someone who I had met in person and had formed a relationship. So you see, there are dangers in having judges engage and meet with litigants and certainly children in this capacity. It was also a very sort of seminal experience in my judicial life. Can I say that a couple of years ago, this young man, I think he was now 21, sent me a card at Christmas and thanked me for what I had done and told me about all of the things that he had achieved in his life. And let me tell you, this is a high-flying achiever. This is an impressive young man. It was very sobering to be able to get that feedback so many years after the fact. So, Darren, Caroline, be careful what you wish for. Okay.
Yeah.
Okay,
Yeah.
it can have impacts that were unintended and unexpected. That doesn't detract from what we're talking about, though.
Well,
these are still important issues.
And Judge, it's so interesting because I suspect for our lay audience, they would say, yes, but the judges should meet us, they should hear from us, they should speak to our children. But you've also touched on that word that's so key to the role of being a judge, and that's objectivity.
Yep.
And that's the thing that enables you to make the tough call when you need to make the tough call. It's interesting for us as independent children's lawyers, because try as we may not to develop a bias in relation to an outcome or a child, and our job really is akin to counsel assisting a royal commission and putting all the evidence to enable a judge to make a decision. It's very hard to park yourself outside the life of those children, that family, and do it completely with an objective state of mind. So, Darren, you face this because you, as a barrister, present on behalf of independent children's lawyers at court, and there is, I call it what you will, a bias or a lack of objectivity, but there is that preconceived outcome that we are advocating for a judge to take on because of our personal experience, and particularly for the solicitor in the past, having often met the child or children.
Yes, I agree. And when I know this is probably a funny thing to say, but sometimes when your client's case is not going as well as what you think, it's kind of weird that you almost try to implore a judge by pulling on a judge's heartstrings in a way in relation to adopting your position for the sake of the child when you're acting for a parent. Now, it's kind of a weird thing to say, I know, but it's you in that situation. Sometimes I think I'm no better than the parents using the children as gun fodder, in that sense. And you've got to be very careful of that when you are representing clients, that you don't become subjective, that you've got their instructions, but naturally you've also got a significant responsibility to the court when your pure focus is the best interest of the children. And of course, that's the judge's job, but all your submissions and everything has to sit well with that principle. Otherwise you have no case. That's what I always think anyhow.
Yeah.
But it's also unethical for us to take on what our clients as parents want. So
that's right.
I actually find it a lot easier, being a lot tougher on my clients to persuade them as to what is the best interest and the best outcome for their children than when I represented children. So it's almost like, I think your objectivity really kicks in when you're representing parents, particularly when you think, oh God, you're playing fast and loose with these kids, and you have such a jaundiced or biased perspective about what's in their best interest when everybody else can see what should be happening, and you're fighting against that. I will take on those tough conversations with clients. But it's different when you meet the kids. It is different.
It is different. And it's nice when you can turn the Queen Mary around and you see the parents' penny drop and they go, oh, yeah, okay. A nice little segue into Lucy, who wrote to us this week. She has a little problem. She says, Dear D&D, my husband Ken and I just separated after 10 years. We have 2 kids, Olivia, who's 8, and Charlie, who's 5. I looked after the kids during the marriage, and Ken was away a lot with his work. He was a good dad when he was around, which wasn't often. Later in our marriage, I discovered he was having an affair interstate. I called him on it and decided the marriage was over. He's been seeing the kids every second weekend overnight and Tuesdays for dinner. He now wants more and more time and wants to extend his weekends to 4 nights a fortnight. 4 nights with a night in the other week. He says his work has changed and he can accommodate this. He says his new partner, Kim, will be around as well. The kids are not settled in as yet on the current routine. Olivia wakes up at night with night terrors, and getting Charlie to school is a real struggle. After he drops the kids back to me on a Sunday, they are tired, cranky, answer me back on occasions. This is unusual for them. The separation has been hard for all of us, especially Olivia, who pines for her dad. She tells me she hates Kim and that she yells at her to do things. I'm concerned Ken is leaving the parenting to Kim as he did with me. What's the best way to tackle this with the kids and Ken? I find it hard to talk to him as we separated on bad terms after I sprung him. Regards, Lucy. Not a too uncommon story, I'm afraid, is it, Judge?
No. Well, yes and no, because
Yes.
the presenting problems are not as great as many of the cases where we have overt risks arising out of family violence, mental health, drugs and alcohol and all that. But here, of course, we've got a potential issue of high conflict and how it's managed, and in particular, how you manage the potentially insidious impacts on the kids. Where to start? I'd love to get Ken's perspective on this, because let's not forget we're only getting Lucy's perspective.
Absolutely.
If if I had these two in court, I would probably get them, to come in an hour early and get a sense of the other cases that are before the court. All right,
Okay.
because you see, they might start to get an appreciation of just how comparatively small their issues are compared to so many other cases that we have in the court system, where, for example, one is really concerned about the risk of harm to children and to parents as well. But where do we start with this?
Well, it seems, look, reading between the lines, and maybe I'm being a little bit harsh on Lucy. I don't know what you think, Caroline, but she seems to have taken up the lion's share of the homemaking and caregiving for the children because of Ken's occupation. But she seems, maybe I'm being a bit harsh in saying it almost seems that she got her nose a little bit out of joint because Kim stepped in and she's worried that she's going to be taking over her role as a mother. So it seems that a little bit of communication mightn't go astray in this case. What do you think, Caroline?
A bit of counselling might help as well. It's it's so fascinating, Judge, that you should say on the Richter scale, if we're talking about damage and if we're talking about trauma, Ken and Lucy are sort of blipping really. So take stock, work out that there is a solution. Darren, I think there is that concept of Lucy being wedded to the narrative of I'm the parent and I'm the only one that knows how to parent. Am I surprised to hear that when there's parenting going on in the other household, it's not good parenting and the children are falling apart at the seams? But again, there needs to be a reality check. And I think counselling is the way to do it. But I also think the two women, Ken isn't going to change necessarily, but Ken may have also been written into his own narrative as a parent. He might have been given a very sort of narrow role by Lucy. And I often say to the women I act for, I say, look, don't blame him. You're the one that's taken over this space. You've taken all the parenting oxygen out of the room. This is somebody that needs a bit of help. And don't you want him to succeed for the sake of your children? Like, it's a no-brainer to me. Don't we want to empower all the adults in the lives of these kids to be the best possible parents or step-parent they can be.
I in fact get the impression, I don't know what you think about this, Judge, but I get the impression these kids might even want more time with their dad. We've got Olivia who's pining for her father. Charlie's coming back and his behaviour is a little bit askew. What do you think about that?
It's possible. One of the first things we need to ascertain is what do the children really want? But I think there's a couple of other things. Might I just make this observation? Gee, you two are tough. You two are tough. What, are we on Sky News or something like that? Yeah. Hang on a sec. Let's give these people a break. Right.
Okay. All right.
It sounds like the separation is very new.
Yes.
Very recent. Okay. So what we typically have, of course, is two parents who are at different stages in the separation cycle. So clearly we've got Ken, who is way ahead of Lucy, just adjusting to the changes in the relationship. We've got the kids who are caught up in all the confusion, the uncertainty, the dramatic changes in their lives. We've got especially Lucy, who I think is, because she's struggling with the emotional catching up that needs to happen when a relationship ends, she's just not seeing things clearly. I'm actually thinking we've got to be careful not to do too much too quickly with this family and just allow some of this process of getting used to the emotional transition to take place. And then we'll find that both, especially Lucy, but possibly both Ken and the kids will be in a better place to deal with it. Now, of course, we're not equipped to do that. We're lawyers. It occurs to me, that Ken could be a family lawyer. He could be a family law barrister, Darren, if he's working away a lot on his work.
Yes, he could be.
So we've just got to consider the human aspect to all of this, the emotional changes, the psychological stuff that is happening, and recognize that we might not have the expertise to deal with these problems, but the more we understand it, the more we can adapt our legal responses to it appropriately. So with Lucy, for example, I think one would have to be really patient, Caroline. Patience and understanding.
That's not my bag. But you're right, Judge. There's that as you say, there's a time frame, if you will, and it ain't necessarily our time frame, and it ain't necessarily the court's time frame. It's the time frame of grieving for the loss of a relationship. I often talk about Ken having bought the ticket on the train. He's already on the train. And poor old Lucy stumbling around 5 suburbs away from the train station, doesn't know what she needs to get on the train, doesn't know how to buy the ticket. Ken's comfortable. He's off. He's running. He's changed his life for the better, so he thinks. Poor old Lucy is playing catch up. And I probably would say that to her. I say, you're catching up. You need the support to understand what it is that's happened to you, what it is that's happened to your family. You're still a family. You're just geographically located in 2 houses now, but there's a new player in town, and the new player it's Kim, is it not? So Kim, Kim's girlfriend. So it is a lot. So if it's a lot for the parents,
imagine. For the kids.
Imagine what it's like for the kids.
But what you say, Caroline, is really important. And the more and more I'm traveling down this road of family law, I realise the importance of validation when you're dealing with people, the importance of validating their feelings and listening to what they've actually got to say. And I mean really listening to what they say. Because I think if you do that, it almost, if you're in a boxing ring, which a lot of clients are, you're almost softening them up so that they can appreciate, so the fog lifts and you can actually speak to them and they can take on. Because our best weapon as lawyers is that every parent, unless they've got a significant mental illness, every parent loves their child and every parent wants what is best for their child. So on that note, I will say thank you very much, Justice Altobelli, for being on this show tonight. You're a wealth of knowledge, as always, and I love listening to your dulcet tones. They're always full of wisdom. And to my fellow podcaster, Caroline Counsel, for joining me, as always.
And thanks, Darren, for hosting.
And not at all. And I'll look forward to seeing everyone again next week. Thank you very much.
Thank you both. Thank you.
Thanks. Bye.